Welcome everybody to Computers, Analytics and Healthcare, What's Patentable at the Interface. I'd like to start by thanking Catalyst, our fantastic partners in bringing this webinar to life. I'm Chris Lang, I'm the Senior Associate Dean for Innovation and Entrepreneurship at the Duke NUS Medical School. It's my pleasure to welcome all of you who are joining us here today. Maybe just by quick way of introduction, Duke NUS is Singapore's first research-intensive graduate medical school. Its Office of Innovation and Entrepreneurship promotes the capabilities of Duke NUS and the Sing Health Duke NUS Academic Medical Centre as a hub for biotech and medtech innovation and commercialisation. One of the ways that we do this is through our Centre for Technology and Development, or CTED, which is our tech transfer group at Duke NUS. They protect new ideas, help to develop commercializable enterprises, and help to license our intellectual property. Joint CTED is our partnership with the Sing Health Intellectual Property Office. If you want to learn more about tech transfer at Duke NUS, please look us up under the Innovation tab on the Duke NUS website. So with that, I'd like to introduce and hand over to my colleague, Cheryl McCaffrey, who is the Director of CTED, and she's going to introduce our speaker today. So thank you, Cheryl.
Thank you very much, Chris, and welcome everybody to today's seminar. It's my great pleasure to introduce our speaker for today, and his name is Dr. Ken Simpson. He's a patent attorney with the patent attorney firm Davies Collision Cave. Ken is a fellow Australian and received his academic qualifications at the University of Adelaide. He holds a science honours degree and a PhD in physics. Ken conducted laboratory research for a total of 10 years, including 5 years in bioinformatics. And before seeing the light and recognising the importance and value of intellectual property rights and deciding to join the patent attorney profession, which he did in 2007. In the meantime, he's become a registered attorney in both Australia and Singapore, and has also worked in the United Kingdom. His practice focuses on obtaining commercially relevant protection for, wait for it, digital technologies, and especially artificial intelligence and other computer-related technologies across a wide range of different industries. I have had the pleasure of working with Ken and his colleagues on one such invention. And I'm sure you'll note that he is therefore eminently well qualified to speak on today's topic. So please stay at the end of our seminar because there will be a Q&A moderated by Sachin, one of my CTED team members. But without further ado, I will now hand over to Ken to present his seminar for today. Ken, thank you very much. Please share your slides now.
Thanks very much, Cheryl, for that very kind introduction. So as Cheryl mentioned, we've been lucky to work together on some technology coming out of CTED, and I've had the great privilege of working with some very interesting technologies coming out of Sing Health and Duke NUS researchers. And some of these technologies have a sort of combination of elements where you have sort of medicine and biology on the one hand and sort of computer science and engineering on the other. And it's at that sort of interface where we have some interesting issues in relation to patentability, and that's what I'm going to cover today. If I can advance my slides, there we go. So just an overview of what I'll discuss. So I'm not going to go into chapter and verse about all the sort of law and all the different cases that are relevant to this area, but I do need to set the scene a little bit. So I'll just talk a little bit about what the key issues are for patentability, and especially in areas such as diagnostics and software implemented inventions. I want to spend the majority of the time talking through some examples of digital health related patents that have been granted, and also some cases where the applicant was not successful and what we can learn from those failures. And then just wrap up with a few sort of key takeaways from all the case studies and some best practices and some ways to give yourself the best chance of succeeding with inventions in this space. So as we probably all know, so there are a number of requirements of patentability, the most important of which is novelty and inventive step. So you have to have something which is new compared to what people have done before and also not obvious. But there are some other considerations. So there is a requirement called sufficiency, which relates to whether you've provided a detailed enough roadmap for somebody in your field to be able to reproduce the invention after the patent expires. That's part of the bargain that you make with the state. So in return for the monopoly rights for 20 years, you have to provide enough information there to effectively put the technology into the public domain for use once the monopoly has expired. And you have to provide enablement for your invention across the full scope of the claims. So quite often providing just one example is not enough. You need to give a really detailed explanation of how the technology works. And that can be an important consideration for certain types of biotech invention and bioinformatics invention. But what I'm probably going to focus on most is this issue of what I would call inherent patentability or subject matter eligibility. And this really is all about whether under national laws something is suitable subject matter for patenting. So different countries have different types of exclusion for particular kinds of subject matter, such as, for example, methods of treatment, which are perfectly allowable in the US, but in European countries, in Singapore, in China, methods of treatment cannot be patented. So you then need to look at sort of different aspects of the technology to protect. So I'll talk about these kind of exclusions and how you can get around them. I think for software and diagnostic inventions, this inherent patentability issue is probably the most important one, even before you start looking at the prior art. So just looking to the US first. So the statute is actually quite liberal in that it effectively says that anything man-made can be patented, but the courts have drawn a bit of a line under that and said, well, actually there's certain types of subject matter that shouldn't be protected by patents. And especially in the last sort of 5 to 10 years, a couple of cases here that I've mentioned, Alice and Mayo, have started to restrict what can be patented. So things like laws of nature and abstract ideas have been held by the courts not to be patentable, and they're very difficult to get through at the US Patent Office. So what do I mean by an abstract idea? Well, that might be something like a mathematical process or something that you could do as a mental process, something carried out in the human mind. And an example of that would be comparing two nucleotide sequences to detect the presence of an alteration. So that is something that you can do manually, and that would be considered to be an abstract idea. An example of a law of nature would be some sort of correlation that you're measuring in the human body, and the Mayo case was just such an example of that, where they were administering a drug, a known drug, to a patient, determining the level of a metabolite in the patient, and then based on the level of that metabolite, deciding or providing an insight as to whether the dosage of the drug needed to be changed or not. And the court in the Mayo case said, well, all you've done in your claim is say, I have found this natural correlation and I report that information. You don't do anything with the result of that information. There's no kind of practical sort of touch point with the real world, or no practical consequence of finding out that you need to change the dosage. So the court said, you're just claiming the law of nature itself. That is not patentable subject matter. And diagnostic inventions often get caught in that law of nature trap. Bioinformatics inventions will often face rejections of being abstract ideas, especially if they're reciting mathematical or statistical steps, and sometimes even the law of nature exception will come into play. So we'll talk about some ways of getting around these issues later. Just to give you a picture of the impact that these decisions have had on bioinformatics patenting in the US. You can see on the left-hand side of this slide the percentage of office actions with 101 rejection. So 101 is the section of the statute that relates to patentable subject matter, and the vertical dotted line is the date of the Alice decision. So you can see that as soon as that decision issued, the US Patent Office started saying, well, basically everything to do with bioinformatics is abstract. So nearly every case is getting at least one office action that's rejecting the claims as being abstract ideas. It's not all bad news. You can see the allowance rates on the right. So the green line is for bioinformatics related technologies, and the allowances have more or less returned to where they were before Alice. So as the courts have refined these tests a little bit and the patent office has gotten used to applying these concepts, bioinformatics patenting is sort of returning more or less to where it was, although it is a little bit difficult, a little bit more difficult than it used to be because of having to negotiate these abstract idea rejections. So how can we get to something that's eligible in the US if we face one of these rejections? Well, as long as we have something in the claim that is reciting a practical application of the abstract idea or law of nature, we then have something more that takes it into eligibility. So to give you an example, if you have something like calculating a ratio of gene expression levels in a patient and diagnosing a disease based on comparison of that ratio to some threshold value, that actually is going to get rejected more often than not as being directed to a law of nature, so the correlation between the ratio and the disease, or even as an abstract idea, you're just computing this mathematical relationship. So to get beyond that, you then need some tie to the real world, and the way that one way that the courts have said you can do that is to then have a treatment step at the end of your method. So you compute your ratio, and the practical application is using that information to then treat the patient, depending on whether the ratio indicates that they suffer from the disease or not. Even if you don't have a practical application, there's perhaps another way to save your claims, and that's to have something unconventional in the claim that takes it away from just the abstract idea itself. So to give you quite a topical example of that, this is a recent case, Exogen, which relates to measuring human core temperature using the scanner that you can see on the right there. But the claim wasn't directed to the temperature scanner itself, it was directed to the method of using it to do a scan. And what the first instance court said was, well, all you have in your claim is a natural law, and the law being that the core temperature of a human being is a function of skin temperature above an artery and ambient temperature, and your claim is just directed to that. But the appeal court, when they took a bit more of a careful look at what was actually in the claim, looked at what the specific steps that were being performed as part of this method. So in the scan, you're moving the detector across the artery at a specific rate, more than 3 readings per second. And that was a specific and concrete method that took it away. It was also not known to have been done previously. And so that took it away from being just the natural law and rendered it patent eligible. So as long as you have something unconventional about the way that you're taking measurements or applying the information or analysing the information, analysing the data, that can take you into eligible territory. Just a note on diagnostic methods. So the kits or compositions used for such methods may be patent eligible depending on what the components are. You can run into difficulty with things like antibody-based diagnostics because the patent office may say, well, you're just using a product of nature in the form of this antibody, and that's excluded subject matter. Another difficulty may be if you're using a known biological entity, for example, it just happens to be in a different application. The entity itself is not novel, it's the application that's new. So you then have to look at trying to protect the method, so the specific application for diagnosing a disease. As we've just been discussing, that may then lead to a rejection that you're claiming a law of nature. So you then may need to add something extra like a treatment step to give you the necessary practical application. That does lead to its own issues. So rather than just being a pure diagnostic method, you now have a method of diagnosis and a treatment, which means you need two people to infringe this claim. You need the person, potentially two people to infringe. So you need the person who's making the measurements for the diagnosis, and then the clinician who's doing the therapy. So that creates a practical issue for enforcement. Moving on to the criteria in Europe. So there are some statutory exclusions for certain things. The first category includes things like mathematical methods, mental processes, computer programs as such. And the other category, as I alluded to before, is diagnostic methods or methods of treatment that are performed on the human or animal body. It's possible to get around these exclusions. So for example, something in the first category, although something like a mathematical method is itself not technical and excluded subject matter, as long as you have something technical in your claim, such as a computer that performs a method, you automatically get around that exclusion. But that isn't enough to give you patentability, because the non-technical part, the mathematical method itself, won't be able to contribute to inventive step under European practice. So as I just mentioned, so something like a computing device or a physical measurement device like a sensor or a measurement process such as a biological assay, these are all technical features that you can include in a claim, but you then need some interaction between those technical features and what would otherwise not be considered to be technical, such as a computer program or a mathematical method, which is being applied for a technical purpose. And some examples of technical purposes can be, if you're controlling a physical system, a medical device such as a drug infusion device or an X-ray machine, if you're using data to make a medical diagnosis using an automated system that processes physiological measurements, or you are providing a genotype estimate based on analysis of DNA samples. Although these are all applying mathematical or computational operations, those are being applied for a technical purpose, and that means that they can contribute to inventive step. So the second category of exclusions is diagnostic methods. This is actually quite a limited exclusion, because to fall within it, you need to carry out the diagnosis directly on the human or animal body, and you need to carry out all these steps, so collecting data, comparing the standard values, and making a diagnosis based on these steps. So as long as you carry out the method in vitro, or you don't actually provide a diagnosis at the end of the method, you won't fall within the exclusion. So it's actually quite limited, and in fact, easier to get around this exclusion than the corresponding exclusion in the US. And just briefly touch on China, which is becoming a much more important jurisdiction now for a lot of technologies. Really, the criteria are very similar to Europe. You need this aspect of technicality. So the invention needs to solve a technical problem using technical means and has to achieve a technical effect. And that can be through, as for Europe, controlling, guiding, or processing something external to the computer, in the case of software invention, or operating on something internal to the computer, which could even be a particular type of data, such as a medical image. So as long as you have some interaction between non-technical things like mathematical methods and technical things such as something in the physical world, you can have something which is eligible in China. China does have an exclusion for methods of diagnosis, but again, that's only if you're performing the method on a human being directly. In vitro diagnostic methods are patentable. So I want to now spend some time talking through some examples of patents that have been granted in the US and in Europe. For one reason, to illustrate some of the differences in practice, but also to show you some of the kinds of subject matter that, well, might run into trouble, but there are ways to get it over the line if the specification and claims are cast in the right way. So the first category of technologies I want to talk about are bioinformatics platforms. Just as a general comment, so what do I mean by this? Well, I guess there are two aspects to these platforms. So there's firstly the methods and computational tools and computing infrastructure for analysing bioinformatics data. But there's also the insights that you gain as a result of that data analysis and what you do with those insights. So the result might be, you know, a set of genes that are useful for diagnosis or prognosis, or patient stratification criteria, these sorts of things. But it's not just those two areas. There might be some other ancillary areas that are worth considering for patenting. For example, there might be some technical problems that you're solving along the way to implementing a system that can carry out a bioinformatics pipeline. So, for example, are you capturing data in a novel way? Are there, you know, unusual novel systems for doing that? Are you doing something to prepare data for entry into the pipeline, pre-processing or other data preparation steps that is new? Or is there something at a more fundamental level of the computing architecture? So are you having to think about how to store data more efficiently or communicate data more efficiently across system components or more securely? So these are aspects that are more general than just your specific application to a bioinformatics pipeline. So if you think holistically about your platform, there may be quite a few different areas that you can capture to protect the platform as a whole. So the first specific example I want to talk about is a patent owned by Berg Healthcare, a US patent that they were able to get granted. And this covers an aspect of their core technology for their interrogative biology platform. So this is a machine learning platform that identifies modulators of biological systems. So you take a group of cells as a model for a biological system of interest. You assay those cells in a number of different ways. So you can collect genomic, proteomic, sequencing data and so on, but also functional data. And by combining those two data sets, you can infer causal relationships and you can generate basically a regulatory network to characterize your system of interest. Now, what the US Patent Office said when they first filed this application was, well, all you have in your claim is a series of mathematical concepts, and your claim is therefore just directed to an abstract idea. So what they then had to do was be a bit more specific about their analysis steps. So how were they generating this causal network? What were they comparing their network to? So they had this kind of differential network analysis where they compared the generated network to a network generated from a control sample. And that differential analysis allowed them to identify relationships that were unique to the system of interest and therefore what the modulators of that system were. And they also, importantly, included some detail of how this was implemented in a parallel computing architecture. So this excerpt from the Notice of Allowance points this out and says that by specifying the implementation in parallel computing architecture in a way which was not routine and well known, or that wasn't so when they had filed their application, there was an improvement in computer technology, and that took it beyond being the abstract idea itself. So the takeaway, I think, from this one is, as well as thinking about the novel data processing steps, it's worth thinking about how the implementation occurs in computing architecture, and if you can then say, well, I really need to have this implemented in a particular computing system that's configured in this way, it's then not just a mental process or something that can be done with pen and paper. The computer is integral to the invention. Now, there was a European equivalent to this application, and that was also objected to initially, and for really stemming from the same issue. The claims initially were far too broad, and they didn't specify how the analysis was done. Now, while in Europe they didn't need to specify the computing architecture, they did need to get more specific about the analysis steps, and they were able to get some allowable claims by doing that. So this is another example of a US patent. This is Brigham and Women's Hospital, and they were actually able to get extremely broad claims here without encountering a patentable subject matter objection, which to me at least is quite surprising. So what this platform does is that it takes functional imaging data, such as fMRI data for a patient, but also obtains clinical data for that patient, and then using multivariate classification, finds covariating traits based on correlations between the functional imaging data and the clinical data. So effectively, they find spatial features in the imaging data that correlate with the clinical parameters, and that can be used to classify patients as having the neurological disorder or not, for example. So I think, although as I said, I think this is a little bit surprising, I think how they were potentially able to avoid patentable subject matter issues was, although this might sometimes be considered to be a law of nature, as in a correlation between the imaging data and the clinical data, what they're correlating is actually something which is an artificial construct, which is features extracted from the imaging data. That's not something that occurs in nature. And so that is possibly how they managed to avoid the problem. So what you have on the screen in front of you is effectively the claim they got, with a bit of paraphrasing, so very broad protection. Now, in Europe, they didn't file an application, but I think they probably would have been fine, because the inputs to the method are images, and the European Patent Office generally considers image data to be technical in nature and methods of processing it to be inherently technical. So they would have been fine on that score, and avoided the diagnostic method exclusion. Even if they had encountered a problem because, for example, the biomarker generated by this process was considered to be some non-technical object, they would probably have been able to get around it by including a specific application of that generated information. For example, using the biomarker to classify a patient to make a diagnosis. This is an example where the patentee or the applicant was not successful. So the invention here is a platform for identifying all possible valid primer pairs from a large sequence database. And the method involves applying a series of sequence analysis steps and a series of filtering rules to identify these valid primer pairs, a subset thereof. Now, the US Patent Office said that this was just an abstract idea, because all the claim does is organize and compare sequence data through mathematical correlations and mathematical operations. And so this was rejected as not being patentable. The examiner said, everything in your claim can be performed in the human mind or with pen and paper, and the only computer implementation here is completely generic. There's nothing special about the implementation. So that claim was rejected, and the applicant is still trying to get it through, but I think that they don't have a lot of chance of success, just because of the breadth of what they're trying to claim, and the fact that what they're producing is in a sense a little bit abstract. It's really a set of filtered data from a larger set without any practical application. And they encountered similar problems in the UK. So the examiner said this isn't patentable subject matter because it's a computer program as such. What you're doing with the computational steps is just filtering a large list to a smaller list, which is still really large. It's an abstract and extensive list of all possible primer pairs. You haven't said what the practical application is. There's no specific application outside the computer and no specific technical purpose for that filtered data set. So effectively, it's just a computational mathematical filtering operation with no practical result at the end. So I think where they probably could have got something patentable is, and I haven't read the specification to see if they did disclose anything which was a specific application, but for example, if it was the use of the filtered set of primers in a PCR system in some way, some specific way, that could have been a practical application that then anchored it sufficiently to take it into the realms of eligibility. So another interesting class of inventions is in the area of automated drug discovery and drug repurposing, which is a really hot application of machine learning at the moment. And so, of course, people are looking to patent in this area. So one interesting patent that I found is a US patent owned by DNA-seq. So this is a machine learning technology which determines if a mutation is a cancer-associated mutation or a resistance mutation. The algorithm searches a crystal structure library to find a therapeutic agent that can target that mutation. That's the sort of practical result of the claim, is that you have a therapy candidate from that search. So the analysis steps in the claim when it was filed were very broad and recited very generally. And so perhaps not surprisingly, the Patent Office rejected this as being an abstract idea, which was simply using a pattern matching algorithm. So effectively, the objection was the claim was too broad. So what the DNA-seq then had to do was be a bit more specific about how they were doing the analysis, and in particular, to bring in a step that was, in US patent parlance, unconventional, or something more than the alleged abstract idea. So they brought in this additional step of classifying mutations based on a plurality of kinase DFG patterns. And that was something that hadn't been done previously in relation to this type of process. And so because it was unconventional, that led to allowance of the claim. So you can see that the way to get around patentable subject matter objections can overlap a little bit with the question of non-obviousness or inventive step. If you can find something which is unconventional or not generally known in the field and bring that into the claim, which of course still describes what you want to cover and what you're doing, that is a way to get around this eligibility hurdle as well. So the takeaway here is, if you can find perhaps a way of using data which is input data which is unconventional, or if you're using a specific type of input data which other people haven't used before in solving the same kind of problem, that can be the unconventional feature that gets you over the line. So this is a case where the patentee was, or rather the applicant was unsuccessful, a Georgetown University application in Europe relating to drug repurposing. And essentially what they aim to do is to take a whole series of candidate ligands which are taken from known therapeutics and see if they will bind to a protein that they want to target. And the way that they do the prediction is to look at the similarity of those candidate ligands to reference ligands that they know already bind to that protein. And they compute this so-called interaction score, which is based on structure and other physico-chemical characteristics of the ligand and the protein. So the problem they had, again, stemmed from the breadth of the claims. So the European Patent Office said, your claims are not clear because they're so vague as to how you compute this interaction score and how you determine the similarity, that I can't work out, and a skilled person can't work out, how you're going to get from the experimental data to the prediction, which is the practically important result at the end. And this also played into a finding of lack of inventive step. The mathematics that they used to get from the data to the prediction was so vague that it couldn't plausibly give the result for the skilled person. So those mathematical steps couldn't be technical and therefore couldn't contribute to inventive step. What the European examiner did say was that if they specified how the scores were computed, for example, in accordance with the way that they had described it in the specification, where they had shown that this particular way of computing the scores was able to accurately predict binding, that more specific method would be patentable subject matter. So it would allow them to establish a link between the mathematics and the prediction at the end. The US case has also been rejected, on the basis that it's just mathematics being performed on a general purpose computer and therefore is just an abstract idea. So you can see the rejection there. So although there are specific formulas in the dependent claims, the independent claims are so broad and not limiting on the type of data that's received and processed that it's too abstract. So they're trying to get this over the line by including steps of validating the candidate ligands and performing an assay based on the validation. I don't think this will help them because the validation seems to be based on automated literature searching, which is something that ordinarily you'll do manually, and this is still going to be considered to be an abstract activity or an abstract idea. And the assay step seems to be just kind of a standard thing that you'll do for this type of screening method. So I don't like their chances. So I think the takeaway is you need to look for aspects that can't be performed in the human mind to take the method away from being something that is going to be accused of being abstract. So the next class of inventions I want to look at is remote monitoring systems, which falls within the broader area of telemedicine. So the first example I have is a ResMed patent, which the problem they're addressing here is being able to adjust respiratory therapy based on the sleep stage of the patient undergoing the therapy. So to do that, they need to work out what that sleep stage is. And so they had, at first instance, had this very broad claim where they obtained sensor measurements of respiration movements, determine the variability in those movements, and then based on the variability, determine what the sleep stage is. That's basically what they had in their claim. And so you can see that that's a very broad and vague way of expressing it. So again, not surprisingly, the US examiner said that this was an abstract idea because the claims were so broad. But they were able to overcome this by being a bit more specific about the data collection and analysis steps. So they included a step of measuring the respiratory movements using motion sensors. And they also brought in further analysis steps of performing a wavelet transform on the raw signal data extracting features from the transformed signals, and then classifying the sleep stage based on the extracted features. So although they did have to narrow their claims, they didn't have to narrow them so much that, that they didn't end up with something valuable. They didn't have to specify, for example, how they were doing the feature extraction or the classification. There were no details in the claim about the wavelet transformation, nor even any specifics about the motion sensors, other than that they were detecting respiratory movements. So I still ended up with quite a broad and valuable claim. And I think the important takeaway there is that you can start off with something broad, but you need to make sure that you have enough fallback positions that anchor your claims to something more specific, whether that's in the data collection stage or the analysis stage, without, of course, being too limiting. So a second case is this Philips patent, which was granted in Europe and also in the US. And actually, this didn't encounter any patentable subject matter objections, but they were still able to get broad claims. So this patent relates to the problem of detecting whether a dementia sufferer is wandering away from a safe area, and to provide an early warning when that might happen. So, for example, you can't rely on GPS signals, because by the time a GPS monitor detects that they've left, is able to work when they're out in the open, they've already left the safe area. So this patent looks at monitoring physiological parameters of the patient and using those to detect the patient's emotional state, and based on that determine the risk of whether they'll leave the safe area. So if the emotional state is detected as being the patient is in an agitated state or a confused state, you get an alert that tells you that there's a risk of them wandering. So as I said, there were no issues with patentable subject matter here. There were no technicality points raised in Europe, and the US examiner didn't say that this was abstract or looking at a natural law or natural correlation. I think what was actually quite important here, and is important in general, is that the specification went into a lot of detail about the technical problem in the background, but also some specifics of the physical measurement processes, such as measuring the galvanic skin response. Now, they didn't have to put those details in the claim, but they did do what I would call sort of over-explaining how the technology worked. And I think that made the invention look plausibly like a technical innovation rather than a sort of abstract concept. So telling a detailed technical story about the problem and its solution, I think, is a very valuable thing to do and very helpful, especially in the US. This was a case where the patentee was unsuccessful, and I think this is a classic case of mere automation of an otherwise known manual process. So the manual process is essentially prescribing medication based on a consultation with a patient, but it just happens to be that the process is conducted in a telemedicine system, so it's conducted remotely. So all that happens is that the healthcare provider obtains information from the patient. They find out what current medications and allergies they have, and then they send off a prescription accordingly to a pharmacy. And this is all done over a communications network. But it's really just simple automation of the existing manual process, and nothing more than that. And so, of course, the US Patent Office says, you're just claiming the abstract idea, and this is not patentable subject matter. So in cases like this, you need to look beyond the conventional manual process and try and see if there are some technical improvements to aspects of the process. So, for example, this step of verifying that the healthcare provider's authorised to write prescriptions, is there some clever way of doing that authentication? Are you using sort of biometric data in a novel way to do that, or some other process which is technical? Do you have a clever way of automatically determining contraindications for the patient based on the current medications and allergies? Are you automatically recommending a dosage regime based on patient-specific information in some non-conventional way? Those are the sorts of things you would need to look for to get this beyond the abstract idea. So I'm running a little over time. I just want to very quickly touch on a particular type of diagnostic method that can be a little bit tricky to patent. And this is where you are using sets of biomarkers as a diagnostic panel. In this case, it was a patent covering diagnosis of eosinophilic esophagitis, EOE, in a subject. This is a paraphrased version of the US claim. So in this claim, you are essentially measuring gene expression levels in the subject for a series of genes. You determine some summarized value for those gene expression levels, and then you determine EOE status based on that summarized value and the comparison of it to some threshold. So that was what they effectively had originally when they filed the application. And the US Patent Office said, well, you can't have that because you're claiming the natural law, which is the correlation between the gene expression levels and the EOE status. So they had to amend their claim to include the treatment step at the end. That took it beyond the natural law to being a practical application of the natural law. So you do the diagnosis and then you treat based on the diagnosis. They have been able to get allowable claims in Europe as well, but they have had to be a bit more limited. And the reason for that is that in the specification, they've described, they have supporting data for a particular set of 22 genes that they show provides a more specific and sensitive diagnosis than prior art diagnostic methods. But that's the only supporting data they have. So they've had to limit their claim to a specific way of computing the gene expression summary based on that specific set of 22 genes, or at least those 22 genes have to be in the claim, because that's all the only set that they've shown has the technical benefit that they're claiming. Whereas in the US, they were able to claim just a panel of at least 10 genes, where one of the genes had to be a specific gene, which I don't recall which one it was. So in that respect, it's broader, even though they have to include the treatment step. So the written description requirement in Europe is much stricter and requires much more supporting data. And so with this type of invention, where you're looking at panels of biomarkers, you really need to find the minimal set that will plausibly provide the technical effect. And that might mean that you need to do quite a lot of extra, at least in silico work, and maybe also some extra wet lab work to get that data to be able to support your claim across its full scope. Otherwise, you could end up with something quite limited, at least in Europe. So just to wrap up and summarize a few key takeaways from these cases, I think with anything software related, you always need to look at where the nexus is with the physical world. So is that in terms of the way that data is collected, for example, sensor measurements from a patient? Are you otherwise interacting with some external piece of apparatus, some medical device that is in communication with the computer that the software is executing on? Are you creating some control signals for that external device? Possibly, you may have an effect on the operation of the computer itself. We talked about improving storage efficiency, improving communication efficiency and security at a sort of more general level. That can take you away from the invention being just an abstract idea. You need to be somewhat specific about the applications that the outputs of data analysis methods are being used for. So that example where we had the filtering of primers, if they had been a bit more specific about how that was, the result was applied, that may have been patentable. We talked about this concept of finding something unconventional about the steps in a method claim. So that doesn't necessarily have to be in the mathematical or computational steps that you're performing as part of the key bioinformatics algorithms. It might be something about the way that you measure the data, obtain the data through measurement processes. It might be something about the way that you prepare the data for entry into the pipeline, the pre-processing steps. Is there something unconventional about the way that you do that? You need to think about what combinations of features give you the technical benefits that you say the invention has. And we talked about sort of biomarker panels and trying to claim sort of potentially subsets of those. You need to show that those subsets have the effect that you say they do. So you might need to look at different combinations of genes in those sorts of inventions. If the novelty is in the mathematical method or something else which the European Patent Office would otherwise say is non-technical, you need to find a link to the technical outcome of the method. So are you making a more accurate diagnosis based on the mathematical steps? Are you generating an alert, as in the Philips dementia patent? Again, the anchor to the real world based on the results of the analysis steps. Is the computer essential to the inventive concept, or is it just being used as a matter of convenience? So are you just taking a manual process and using a computer because computers are good at automating things? If you are, then you may not have something patentable unless there is something in one of those steps which is being done in an unconventional way. And we saw that people are running into a lot of difficulties, at least at the outset, if they claim very broadly in terms of analysis and data collection steps. You can do that, but you need to make sure that you have enough good fallback positions in the claims and the specification that are directed to specific applications that are commercially relevant to you. So that's all I have, but I'm very happy to now have a bit of a Q&A, which I will hand over to Sachin to coordinate.
Yeah, so firstly, I'd like to thank Ken for this really interesting talk. So both at Duke and US and Sing Health, we've been receiving a number of inventions in all the areas that you covered. So I'm sure this is useful both for us and the inventors. So we have a couple of questions in the chat, but I think I'd like to start off by asking, so you mentioned that sometimes you would have to add limitations in the claims by way of an unconventional step. And I presume that is only to make a patent ineligible subject matter patent eligible, because it is a bit confusing, because even for the inventive step inquiry, there needs to be something unexpected. Of course, that's based on the prior art.
Right.
But I'm guessing there is a clear distinction between the unconventional step requirement for patent eligibility and for inventive step, right?
Yeah, I mean, it's a really good question. And I think, unfortunately, the courts have kind of confused the two issues by bringing in this kind of inventive step inquiry into subject matter eligibility. So they are, unfortunately now, at least in the US, they are quite linked. But I think probably in a sort of general sense, if the unconventional part is in an aspect which is not technical, then it may not be enough to get you over the line. Certainly in Europe, it wouldn't be enough. In the US, it might be. So, yeah, it's a tricky question and a quite confused area.
Okay. So, because if we look at the example of the primer pairs claim that you showed, you seem to suggest that, adding the limitation that the primers can be applied in a PCR system would render it patent eligible. But could it be argued that it probably doesn't carry any patentable weight because primers are going to be used in a PCR
Right.
system anyway?
Yeah, exactly. So, I mean, that was, I guess, just by way of example, and there would have
Okay.
to be, I think, something a little bit more specific about the application.
Okay.
If it's something, certainly in the US, if it's just something that you would conventionally do as a consequence of having generated this list, that won't be persuasive, I think. So the example I mentioned where they were the drug repurposing case, where they're performing an assay to test actually whether does that candidate ligand actually bind to that protein. Of course, you would do that as part of that process, right?
Okay.
The sort of wet lab validation. So although the examiner hasn't responded on that yet, I don't think that would be persuasive for that reason.
Okay. So I'll move on to some audience questions. So Matthew asks, where do polygenic risk scores without treatment algorithm land on patentability in the US, Europe, and Singapore? So I guess you haven't touched on Singapore, so maybe we can also talk a bit about that. So it's about polygenic risk scores, which without a treatment algorithm. So I guess he's asking about patentability of just the risk scoring computations.
Yeah. So I guess the idea here is that you compute a risk score and you report that as information to inform sort of genetic counselling or whatever. I think without treatment at the end, it will be difficult to get that across the line in the US. In Europe, you might be okay because there is a particular example which I mentioned at the start, an example in the examination guidelines which says if you're doing some mathematical steps to generate a genotype, do a genotype analysis, that's a technical activity. So if you're computing these scores in a novel way, I think that would be something that could contribute to inventive step in European practice. And I think probably in Singapore also, you would be able to get something to claim to that sort of method.
Okay. So Parakalan would like to know if claims directed to novel compound structures produced by an AI software, when fed with a target sequence, whether those claims have chances of getting granted, or will it not be directed to the product but to the method of generating the structures?
Yeah, well, this is a really good question, and I think it's a case where you have both categories of invention, right? The platform itself, the method, plus the results of the method. And I think if you're generating something which is novel, those structures themselves would be independently patentable, no doubt. I mean, this is a physical entity which is new and presumably also inventive. So that's something that you can patent without question. And I think also the software could be patentable. But again, it just depends on the details. So, are you having some unconventional sort of machine learning steps that are being implemented by the software to generate these novel structures? I mean, you have a tangible result at the end of this algorithm. So I think you could argue that's not just abstract. This is something that is generating a useful real world result.
Okay.
Yeah, and look, I know that a lot of companies are working on this kind of thing, and I was just having a look at there's a company, Benevolent AI, which does automated drug discovery, and just looking at their portfolio, they are patenting both of these aspects. So aspects of the AI methodology, but also the specific results for particular diseases, treatment of specific diseases. So yeah, definitely both aspects of patent, I think.
Okay. So I have a question just to follow up on Parakalan's. So I think when you identify a new compound using AI, uh, generally if you synthesize a new compound using some chemistry, for sufficiency, you would have to describe in detail how you synthesize the compound in the lab. Whereas if you create a compound using AI, the description, so what do you think the description should look like? If you've actually not synthesized it in the lab, but you've just synthesized it virtually. Um, so yeah.
Yeah, a good question. So I think at the very minimum, you need to describe the AI architecture. So if it's a neural network, what does a neural network look like, and what are the detailed data processing steps? But I think also you need to go into quite a bit of detail about how you get the data into the AI. So what are the source data exactly? Where are you getting that from, and how are you getting that ready to be processed? I think that's also quite important.
Okay. So just to request the audience to actually type the questions in the chat or the Q&A. Okay, a question from Cheryl was, how powerful will a computer need to become before the patent offices will accept that the computation is beyond the capability of the human mind?
Yeah, it's almost a philosophical question, but I think, unfortunately, as technology becomes more advanced and computers become more powerful, I think that makes patentability more difficult. Maybe not even from the perspective of patentable subject matter, but more from the question of obviousness. So if we have these powerful tools available, then any skilled person in the field can just put data into them and get the result. So it might actually be inventive step, which becomes the more difficult thing rather than patentable subject matter. But as for the eligibility question, I think you really need to show that either the data is such that a human just can't process it. For example, pixels of an image is not something that a human brain can process to to classify an image, but based on the pixels themselves rather than the image as a whole. Something like that shows you that, okay, yeah, you really do need a computer to do this. It can't be just a mental process.
Okay. So I think when you showed the patent from Georgetown University, I thought initially one of the ways in which you can overcome the patent ineligibility is by, I think, was it the machine or transformation test? Um, so when you say that the mathematical formula or the algorithm is so disconnected from the prediction that it was not granted, can it be argued that the mathematical algorithm actually enabled the computer to solve a virtual problem which it never solved, which it could never solve without the algorithm, and hence it's kind of transforming the computer to do something that it probably would never do, right? Is that
Yeah, a good question. So I think people have tried to run that machine or transformation argument in the US, and the courts have always said, well, you can have a machine, as in a computer, and you can even have a specifically programmed computer, which is transforming it from something that was general purpose to something that's specific purpose for doing that computational task. But that's not enough on its own. Okay, so if you're just taking a mathematical process and you're implementing it in a generic computer architecture, that doesn't improve the computer sufficiently for it to not be an abstract idea. So in the US, unfortunately, that argument doesn't fly. And in Europe, it may or may not. It really depends on, as in that Georgetown case, how you're tying the mathematics to the output, which is something concrete and useful in the real world, which in that case was the prediction binding affinity, prediction as to whether the ligand will bind. And to have that link there, you need to make sure that you actually, explain how does it do it? How do you get from the data to the prediction? Rather than just these sort of abstract steps of, we apply machine learning to do it. You need to explain how that's done, certainly in the specification, but also to some extent in the claims.
Okay. So someone's told me that Mean Lok has raised their hand, but you really need to type the question in the Q&A or the chat for me to bring it up. Yeah. So just for the audience, if you have any last-minute questions, please do type it in the Q&A. So maybe we can talk a bit about sufficiency when it comes to these kind of patterns. So I know that when you have a broad claim covering a product, you kind of need to write a detailed description of how you made the full range of products.
Right.
So I guess with AI, most of these patterns relate to methods. And I'm guessing with a lot of these machine learning or neural network type things, there would be a range of inputs and a range of outputs, especially when you're predicting risk percentages, etc. So, how detailed does the description need to be, and do you really need to cover like the entire range of possible inputs and outputs?
Yeah, I think it depends on the type of algorithm that you're using. I think if you're using adapting well-known what I would term classical statistical algorithms such as regression or these kinds of things, it's not necessary to go into chapter and verse about those because it's well understood how that works. I think you could run into difficulty with something like deep learning, which is a bit of a black box. I mean, you're not even, in that case, you're not even selecting the way that the inputs are prepared, the so-called feature extraction step. So you are just plugging numbers into this black box to get the result, and it's not necessarily clear how you get to the result.
Okay.
So to get around that issue, at least for something like a deep learning-based platform, as I mentioned before, you need to describe at least the network architecture, which shows, okay, we have this many layers in the network and we have this many nodes and we feed it this kind of data and we use this kind of weighting for all the nodes. Okay. If you provide that level of detail so that somebody can take the same input data and get the same results, I think that's enough.
Okay. Okay, thanks. I think we have no further questions. So again, thanks to Ken for giving this lecture, and thanks to the attendees for attending and raising a few questions. So I guess Catalyst has also organized the next webinar. You can see the dates and the details there. So I guess they will be sending out emails and you can register on it. So yeah, that's it from us for today. Thanks, Ken and the attendees, and have a good afternoon.